Hello everyone, this is Apurva, a legal intern in LEXCLIQ company. For today, I'm going to talk about general defenses which are available under tort. So basically, this video contains what are the general defenses, their meaning, and relevant case laws. So before going to know what is the general defenses of the tort, what is tort? The word tort originates from the French language, so it is equivalent to the English word wrong and Romanian law term. Delicit. It is derived from the medieval Latin from word tortum, which means wrong or injury, which itself was further developed from the old Latin word torquere, which means to twist. So it is a breach. Basically, it is a breach of duty which amounts to a civil wrong. A tort arises when a person's duty towards others is affected. An individual who commits a tort is called a tortfeasor or a wrongdoer. So, and where there are multiple individuals involved, then they are called joint tortfeasors. So, their wrongdoing is called a tortious act and they can be served jointly or individually. So, the main aim of the law of torts is the compensation of the victims. So, Section 2, subclause M of the Limitation Act 1963 addresses tort as a being a civil wrong which is not just exclusively a breach of contract or a breach of trust. The first defense is voluntary not fit injuria. So, in case a plaintiff voluntarily suffers some harm, he has no remedy for that under the law of tort and he is not allowed to complain about the same. So, the reason behind this defense is that no one can enforce a right that he has voluntarily abandoned or waived. So, consent to suffer harm can be expressed or implied. To say, in case Iliad vs. Vikes, a trespasser got injured due to spring guns present on the defendant's land, he knowingly undertook the risk and then suffered injuries for the same. This was not actionable and the defendant was not liable in the case. The second defense is what if plaintiff is the wrongdoer? So there is a maxim extirpi causa non oritur actio which says that from an immoral cause no action arises. So if the basis of the action by the plaintiff is an unlawful contract, then he will not succeed in his actions and he cannot recover damages. So if the defendant asserts that the claimant himself is the wrongdoer and is not entitled to the damages, then it does not mean that the court will declare him free from the liability, but he will not be liable under this head. Next defense is inevitable accident. So accident means an unexpected injury, and if the same accident could not have been stopped or avoided in spite of taking all due care and precautions on the part of the defendant, then we call it an inevitable accident. So it serves as a good defense as the defendant could show that the injury could not be stopped even after taking all the precautions and there was no intent to harm the plaintiff. So in Stanley versus Powell case, the defendant and the plaintiff went to pheasant shooting. The defendant fired at a peasant, but the bullet, after getting reflected by an oak tree, hit the plaintiff and he suffered serious injuries. The accident was considered as an inevitable accident and the defendant was not liable in this case. Then comes the defense act of God. So act of God serves as a good defense under the law of torts. It is also recognized as a valid defense in the rule of strict liability in the case of Rylance versus Fletcher. So the defense of act of God and inevitable accident might look the same, but they are different. So act of God is a kind of inevitable accident in which a natural forces play their role and causes damage. For example, heavy rainfall, storms, tides, etc. In Ramalinga Nadar versus Narayan Reddyar case, the unruly mob robbed all the goods transported in the defendant's lorry. It cannot be considered to be an act of God and the defendant as a common carrier will be compensated for all the loss suffered by him. Then there is private defense. So the law has given permission to protect one's life and property, and for that it has allowed the use of reasonable force to protect himself and his property. So the use of force is justified only for the purpose of self-defense. There should be an imminent threat to a person's life or property. So for example, A would not be justified in using force against B just because he believes that someday he will be attacked by B. Then the defense mistake is available. The mistake is of two types: mistake of law and mistake of facts. In both conditions, no defense is available to the defendant. When a defendant acts under mistaken belief in some situations, then he may use the defense of a mistake to avoid his liability under the law of tort. So in Morrison versus Ritchie and Company, the defendant by mistake published a statement that the plaintiff had given birth to twins in good faith. The reality of the matter was that the plaintiff got married just 2 months before. The defendant was held liable for the offense of defamation, and the element of good faith is immaterial in such cases. The next defense is necessity. So if an act is done to prevent greater harm, even though the act was done intentionally, it is not actionable and serves as a good defense. So it should be distinguished with the private defense and an inevitable accident. So the following points should be considered. In necessity, the infliction of harm is upon the innocent, whereas in case of private defense, the plaintiff is himself a wrongdoer. In necessity, the harm is done intentionally, whereas in case of inevitable accident, the harm is caused in spite of making all the efforts to avoid it. The last defense is statutory authority. So, if an act is authorized by any act or statute, then it is not actionable even if it would constitute a tort. Otherwise, it is complete defense and the injured party has no remedy except for claiming the compensation as may have been provided by the statute. So, the immunity under statutory authority is not given only for the harm which is obvious, but also for the harm which is incidental. So, in Vahan versus Tafwalde Railway Company case, sparks from the engine of the respondent's railway company were authorized to run the railway, set fire to the appellant's wood on the adjoining land. It was held that since they did not do anything which was prohibited by the statute and took due care and precaution, they were not liable. That's it for today, friends. If you like my video, please subscribe to the channel. Thank you.